How UK regulatory technology and enforcement systems actually work. Introduction. When people think about regulation in the UK, they usually imagine laws, fines, or court cases. They think about rules being written and then enforced after something goes wrong. In reality, modern regulation in the UK is deeply technological. Regulators do not just read reports or wait for complaints. They operate large-scale digital systems that monitor, collect, analyze, and act on data continuously. These systems sit quietly in the background of financial markets, telecommunications networks, utilities, transport, healthcare, and online platforms. This video explains how UK regulatory technology and enforcement systems actually work. It is not about individual scandals or political debates. It is about infrastructure. We will look at how regulators are structured, how they gather information, how enforcement decisions are made, and how technology enables regulation at national scale. What regulation means in practice. Regulation in the UK is not a single activity. It includes licensing, supervision, monitoring, investigation, enforcement, and remediation. Different regulators focus on different sectors, but the underlying patterns are similar. Most regulation follows a life cycle. First, rules are defined through legislation and regulatory guidance. Second, regulated organisations are required to provide information. Third, regulators analyse that information to identify risk. Fourth, interventions are applied when thresholds are crossed. Technology underpins every step of this process. The UK regulatory landscape. The UK does not have one regulator. It has dozens. Some regulate markets, some regulate safety, some regulate data, some regulate behaviour. Key regulators include the Financial Conduct Authority, the Prudential Regulation Authority, Ofcom, Ofgem, the Information Commissioner's Office, the Competition and Markets Authority, and the Health and Safety Executive. Each regulator is created by law and given specific powers. They cannot act outside those powers. This legal framing strongly shapes how their technology systems are designed. Why regulators rely on technology. Modern UK society generates enormous amounts of activity, millions of financial transactions, billions of data points, continuous network traffic. Human oversight alone is impossible. Regulatory technology exists to scale supervision. It allows regulators to move from reactive enforcement to proactive risk detection. Instead of asking whether a rule was broken, systems ask whether conditions are forming that make harm more likely. Regulatory data collection. Most regulatory data does not arrive as a single report. It arrives continuously. Banks submit transaction data. Telecoms operators submit network performance data. Energy companies submit supply and pricing data. Online platforms submit transparency and risk reports. This data is structured, standardized, and legally mandated. Failure to provide accurate data is itself a regulatory breach. Reporting obligations and systems. Regulated organisations interact with regulators through digital reporting systems. These systems define schemas, validation rules, and submission schedules. Data is often submitted via secure portals or automated interfaces. The goal is consistency. Inconsistent data cannot be supervised effectively. Regulatory reporting systems are therefore conservative by design. Changes are slow, controlled, and carefully tested. Risk-based supervision. UK regulators do not treat all organisations equally. They use risk-based models. Firms are scored based on size, complexity, past behaviour, and systemic importance. Technology systems continuously update these risk profiles. High-risk entities are monitored more closely. Low-risk entities face lighter supervision. This allows regulators to focus limited resources where harm would be greatest. Monitoring and surveillance systems. Surveillance systems sit at the heart of regulatory technology. In financial markets, these systems look for unusual trading patterns. In telecoms, they look for service degradation or systemic outages. In energy, they look for supply manipulation or pricing anomalies. These systems use rules, thresholds, and increasingly machine-assisted analysis. They do not make legal decisions, they surface signals. Alerts and escalation. When monitoring systems detect anomalies, alerts are generated. Not every alert leads to action. Most are filtered, triaged, and contextualized. Human analysts review alerts alongside additional data. Only when multiple indicators align does an issue escalate. This protects organizations from arbitrary enforcement while allowing early intervention. Investigations. When regulators investigate, technology plays a central role. Investigators access historical datasets, communication records, transaction logs, and audit trails. Evidence must be handled carefully. Chain of custody matters. Systems are designed to preserve integrity and traceability. Investigations can last months or years. Technology allows continuity across staff changes and time. Enforcement actions. Enforcement is the visible outcome of regulatory systems. It may include fines, license restrictions, remediation orders, or criminal referral. Technology does not decide punishment. It provides the factual basis for decisions. Enforcement actions must withstand legal challenge. This places high requirements on data accuracy and system reliability. The role of courts and tribunals. Regulatory enforcement does not exist in isolation. Courts and tribunals act as external checks. Evidence produced by regulatory systems must be explainable. Black box decisions are unacceptable. This limits how far automation can go. Human accountability remains central. Cross-regulator coordination. Many risks cross regulatory boundaries. Financial crime touches finance, data protection, and law enforcement. Cyber incidents affect telecoms, energy, and public services. Regulators coordinate through shared frameworks and secure information sharing. Technology enables coordination without centralizing control. National security and sensitive regulation. Some regulatory systems intersect with national security. Telecommunications, energy, defense supply chains, and critical infrastructure fall into this category. Additional safeguards apply. Access controls are stricter. Audit requirements are higher. Technology systems are often isolated and hardened. Suppliers and technology providers. Regulators rarely build all systems themselves. They rely on specialist suppliers. These suppliers must meet strict security and integrity standards. Vendor risk is itself regulated. Procurement decisions consider long-term resilience, not just cost. Cloud and hosting choices. Most regulators now use cloud infrastructure. However, data sensitivity determines architecture. Some systems run in public cloud, others use private or hybrid environments. Decisions are driven by risk, not fashion. Data protection and oversight. Regulators are subject to the same data protection laws they enforce. This creates internal compliance obligations. Systems must support access controls, audit logs, and data minimization. Oversight bodies review regulator behavior. No regulator is unaccountable. Transparency and public reporting. Many regulatory outcomes are published. This transparency is intentional. It shapes market behavior. Technology systems support publication, reporting, and statistical analysis. Public trust depends on consistency and clarity. Limitations of regulatory technology. Regulatory technology is powerful but limited. It cannot predict every failure. It cannot replace judgment. False positives and false negatives exist. Systems are tools, not authorities. Understanding this prevents over-reliance. Why UK regulation looks the way it does. UK regulatory systems reflect legal tradition. They prioritise due process. They favour proportionality. They resist full automation. This makes systems slower but more defensible. At national scale, legitimacy matters as much as efficiency. Sector-specific regulatory systems. Regulatory technology differs significantly by sector. In financial services, supervision focuses on market integrity, consumer protection, and systemic stability. Regulators ingest transaction-level data, balance sheet information, liquidity metrics, and behavioral indicators. Surveillance systems look for patterns such as insider trading, market manipulation, mis-selling, or liquidity stress. These systems operate continuously and are calibrated differently for retail banks, investment firms, insurers, and market infrastructure providers. In telecommunications, regulatory systems focus on availability, resilience, competition, and lawful access. Network operators submit detailed performance metrics covering outages, latency, congestion, and coverage. Regulators monitor whether providers meet service obligations and whether failures could cascade into emergency services or national disruption. Lawful intercept capability is regulated separately and subject to additional safeguards. In energy, regulation focuses on supply security, pricing fairness, and infrastructure reliability. Data flows include generation capacity, demand forecasts, grid stability indicators, and market pricing information. Monitoring systems look for manipulation, underinvestment, or systemic fragility, especially during periods of peak demand or geopolitical stress. In healthcare, regulation focuses on safety, quality, and data protection. Digital systems track incidents, outcomes, and compliance with clinical and operational standards. Because patient data is highly sensitive, regulatory technology in this sector is deliberately constrained and heavily audited. Preventive regulation and early intervention. Much of modern regulatory technology is designed to prevent harm rather than punish it. Early warning indicators are embedded into supervisory systems. These indicators do not prove wrongdoing. They signal rising risk. For example, a sudden change in transaction patterns, complaint volumes, system outages, or staffing levels may trigger supervisory engagement. Regulators may respond with requests for information, targeted reviews, or requirements for corrective action. This form of intervention often happens quietly. Its goal is stability, not publicity. Continuous supervision models. Traditional regulation relied on periodic reviews. Modern systems support continuous supervision. Data feeds are ingested daily or even in near real time. Dashboards track trends rather than snapshots. This allows regulators to see deterioration before failure occurs. Continuous supervision does not mean constant enforcement, it means constant visibility. Model risk and validation. Regulators increasingly rely on analytical models. These models score risk, prioritize supervision, and allocate resources. Model risk is therefore itself regulated. Regulators validate their own models, they document assumptions, they test sensitivity, they audit outcomes. This meta-regulation prevents technology from quietly distorting enforcement. Explainability and accountability. Any system that influences regulatory action must be explainable. Regulators must be able to explain why an organization was flagged. They must be able to justify escalation. They must be able to demonstrate proportionality. This requirement limits the use of opaque algorithms. Transparency is not optional, it is foundational. Human roles in regulatory technology. Despite extensive automation, humans remain central. Analysts interpret signals, supervisors exercise judgment, legal teams assess evidence. Senior officials make final decisions. Technology supports these roles, it does not replace them. Crisis response and stress events. Regulatory systems are stress-tested through crises, financial shocks, cyber incidents, infrastructure failures. During stress events, data volumes spike and decision timelines compress. Systems must support rapid coordination and accurate situational awareness. Post-incident reviews feed back into system design. International coordination. UK regulators do not operate in isolation. Markets and networks are global. Regulatory technology supports data sharing with international counterparts. Standards bodies, bilateral agreements, and multilateral forums enable coordination. Technology enables alignment without surrendering sovereignty. The future of regulatory technology. Regulatory technology will continue to evolve, data volumes will grow, automation will increase cautiously, artificial intelligence will assist analysis but not replace accountability. Legal frameworks will continue to shape technical design. The UK model will remain incremental rather than revolutionary. Closing. Regulation in the UK is not just law, it is technology, process and governance combined. Understanding regulatory systems explains how modern Britain manages risk at scale. It explains why enforcement looks the way it does. And it explains why technology quietly shapes everyday life far beyond what most people see. This is how UK regulatory technology and enforcement systems actually work.